Okay. Um, can everyone see my screen? Yes, Janice?
Yes.
Yes, perfect. Okay. All right. Hello, everyone. Thank you so much for joining us today in the INet's annual event on immigration. My name is Angelina. I'm a postdoc at NYU Langone, and I'm serving as institutional representative for NYU and member of the board at INet-NYC. Before we get started with our today's event presented by our speaker, Brendan Delaney from the Frank and Delaney Immigration Law Office, I just want to take a few minutes to introduce INET to everyone. I also want to ask everyone to please mute your microphones and turn off the video in order to not overload the Zoom connection. And you can also ask your questions in the Q&A. After the presentation, we will try to cover as many as possible. So to get started, very briefly, I want to talk about INET. INET stands for International Networking. Oh, some echo, please mute yourself. So INET stands for International Networking New York City, and it was founded in 2014. So this year is marking the 10-year anniversary for INET. The INET Association was founded to create a community among international STEM scientists in the New York City metropolitan area. And through INET, international students and postdocs can receive help about their professional development, as well as extend their network and receive information and support for various topics, such as today's topic on immigration and visa opportunities. INET lists more than 900 members, and the board consists of international scientists based on New York City metropolitan area. And as you can see, we have many institutions that they are getting represented by INET, and we have regular board meetings, so you can see a screenshot from one of our monthly board sessions. We encourage everyone to join INET's community and get benefited from all the different events we are hosting, and also get a more active role if you would like to further develop your soft and leadership skills, as well as promote INET mission. And with that, I want to thank the co-founders of INET, Ariola and Mike, as well as our current president, Aishgil, and all the people in the INET board team, Gabi, Deep, Jenny, Stayan, and of course, all our sponsors, and especially Frank and Delaney Immigration Law Office for their constant support. Now, our next social event is quickly coming up. So please join us on November 9th for coffee, tea, and mingling at Remy 43, whereas we will be also continuing our Becoming a Faculty one-on-one series, which will be focusing on how to launch your lab in the next month. So please stay tuned. You will be receiving information for all these and future events by simply signing up to our newsletter. And without further delay, I'm going to stop sharing my screen and introduce our today's speaker, Brendan. And just keep in mind that this webinar is getting recorded, and after today, we're gonna upload it in the INET YouTube channel. So Brendan is a native of Northern Ireland, received his Juris Doctor at the Catholic University of America in Washington, D.C. in January 2009. Focusing on the representation of foreign-born nationals and U.S. employers with their U.S. immigration matters, his work includes an emphasis on extraordinary ability and national interest waiver cases, as well as EB-1B, term, J waiver, H-1B, and O-1P visa applications. Brendan works extensively with scientists, researchers, physicians, and other professionals, as well as organizations and employers in both academia and industry. He assists with their temporary and permanent visa applications on a company individual and institutional basis. He has been invited to speak on a number of occasions at the annual meeting of the National Postdoc Association, NPA, and NAFSA Region A, as well as conducting legal seminars at universities and institutions across the United States. Brendan has co-authored numerous articles related to postdoctoral issues for the Postdocket quarterly newsletter of the NPA and currently serves on the Advisory Council. He has also been quoted in a number of news and media articles related to immigration issues for scientists and researchers. Brendan, thank you so much for being today with us. And without further delay, the floor is yours.
All right. Well, thank you very much. Thanks for the invitation to come and present again to INet. It's always usually a very well attended event. We get good feedback, and I think everything you guys do for the community yourselves. So yeah, I'll go ahead and get started. So I'm going to go ahead and share my screen, and that should be it. And everybody should now be able to see my screen, and I will go ahead and get started. So yeah, we're going to talk about green card and other visa opportunities and pathways for scientists and researchers in the US. Yes, I am a lawyer. No, this is not legal advice. Okay, so just that's the disclaimer at the start that this is for educational and informational purposes and should not be used as a substitute for individual legal advice. So in terms of a specific issue or particular situation, an attorney should be consulted with respect to your personal case or situation. With that in mind, at the end, we will do some Q&A. I will be able to answer some questions a little broadly. I won't be able to go into specifics of particular situations. But with that out of the way, we'll go ahead and get started. And when I do these sessions, I usually like to sort of give a couple of takeaways, I suppose. So what would 2 takeaways be as you navigate or start on? I don't know. Some of you guys may be halfway through this journey towards the end, but it is a journey. But I think it's important to be ready to be flexible and also recognize that as you pursue these goals, to recognize your short, medium, and long-term options. So there's going to be short, medium, and long-term goals at play as you take these steps, as you navigate the visa and immigration journey in the United States. So what about postdocs? What about international postdocs and sort of early mid-career researchers in the United States? So more than 50% of postdocs in the United States are in fact foreign nationals. Now, some of you guys may have been here for undergrad, some of you guys may have been here for graduate education and so forth, but now you're further down your career path. So you're facing different issues. You're facing different life issues, but you're also, more importantly for tonight's or for this evening's discussion, you're facing different visa and immigration issues. So what's in front of you? Well, as you come out of your PhD, you can get your OPT. If you do that on an F1 visa, you get your optional practical training, plus a 2-year STEM extension. Then we have a J1 research scholar visa, that's good, generally good for up to 5 years. And then the H1B, that's good for up to 6. So conservatively speaking, and I appreciate that not everyone will take the same pathway and not everyone will navigate this in the same manner, but conservatively speaking, there are sort of 14 years of temporary visa available to you. And that's without getting into other visa options like the O1 and things like that. But those are the most probably, I suppose, commonly utilized visa options, certainly in an academic standpoint. So who can help? Who can help as you start to take these steps and ask questions and sort of work out how you're gonna make this play out for you? Well, in academia, just remember that you're still under the umbrella of the international office. So even, for example, if you did your PhD at University A and you are now working at University B or Institution C on the OPT or the STEM extension, you're still under the umbrella of your international office. And that matters that you talk to them because, we all have friends, we all have colleagues. There's also a lot of online friends and online colleagues these days. But make sure that you talk to the people who matter within your organization or your institution. For example, titles and positions matter. They can be different at different institutions. So important to stay in touch with your international office in terms of personal and professional questions related to your visa. Also, your career office, ask questions about them, what other options might be on the table, and also your postdoc office and or networking organizations like INet, being proactive just like today. So really good to have everybody here today. So what does being proactive mean? Well, in terms of the organizations, the entities, organizing seminars and programs, you should be keeping abreast of changes and things like that. So there are a number of ways that companies, organizations can help. So reaching out and interacting with your international office, your PDO or your PDA, and or organizations such as INet. Just keep abreast of the resources and the opportunities that are there to obtain information about the process and the different sort of facets within that. So basic knowledge, stay informed. US immigration is very broad. And so a lot of the issues that you'll sort of see in the news or you're hearing in the news about the border and things like that, there's a lot of stuff that will not impact you. So it's important, I think, to stay informed and obtain the appropriate knowledge about the factors and issues that do, in fact, affect you and impact you. So what's been happening in the world of US immigration, especially with regards to what I would term high-skilled immigration and employment-based immigration, the manner of which would affect you guys. We are now in, and by the way, this is not news to anyone from India or China, but for everyone else, we're now entering a period of visa backlogs. So everyone needs to strategize about the medium and long-term goals and the sort of strategies that they're looking at in terms of pursuing both temporary visas and ultimately permanent residence. I think it's fair to say we are seeing more uncertainty about timelines moving forward. And what I mean by that is we're seeing delays and inconsistent timelines. Obviously I file a lot of cases for scientists and researchers, and I wish I could say that the timelines for adjudication were consistent, and they're not. So we do see delays, we do see inconsistent timelines in terms of how long it's taking USCIS to look at, review, and adjudicate cases. For I-140 national interest waiver applications, I think it's fair to say as we've moved into the second half of 2024, we're now seeing additional processing delays. We're also seeing, certainly anecdotally, some a little bit more strange decisions and adjudications, slightly some inconsistencies there. But certainly at the start of this year, sort of about 9 months ago or whatever, we were seeing EB2 NIWs being adjudicated relatively quickly. That's not necessarily the case right now. Assuming you get approved for your underlying case and you're moving towards a green card and you're adjusting status to permanent resident, right now, most employment-based cases are being undergone final processing without an interview. So they're engaging in sort of more administrative processing and issuing green cards without a need for an interview. A lack of combo cards being issued. Well, what does that mean? When you file for your adjustment of status, i.e. the final step in the green card process, you can file for temporary work and temporary travel. And for a number of years there, they were issuing what we call the combo card. The work and the travel were being issued together. And now they seem to be separating those out for the most part. They are prioritizing the EADs, the work, but the travel is taking quite a long time. So that leads to collateral damage for some people. So you may be able to work, but not travel. Now, people on H-1Bs aren't necessarily impacted by that, but if you're able to file your adjustment of status from another status, i.e. F1J1, then you may end up in a position where your work permit is issued, but you're waiting on your advance parole, your travel permission. What about traveling on an F1 after filing either a PERM or an I-140? Is that permitted? Well, a December 2023 advisory would suggest the answer to that is yes, excuse me. But one thing I would suggest is when traveling, when making arrangements to travel after having filed a green card, especially for anyone on an F or a J, is to proceed with caution and take legal advice or professional advice before making arrangements to travel. Fortunately, we did see filing fees increased at the start of April. One thing to remember is that USCIS are in fact a self-funded agency. So they are claiming that these filing fees will lead to better processing, and more sort of consistent and timely adjudications. Let's see. The jury is out, as they say. So what else is going on? Well, STEM is helpful. There's been a lot of talk over the past few years in terms of, especially in the world of high-skilled immigration, about deference to STEM and looking at STEM, how can we weigh STEM in a more positive manner? Well, over the last couple of years, that has now actually started to happen. So we've had January 2022 and June of 2023, we have had guidance from the Biden administration indicating that the evaluation of evidence for national interest waiver applications and O1s can be granted more weight for applicants with a STEM background. For example, if you have a PhD in STEM, that can be seen as being persuasive for an NIW application, with additional weight being granted to, for example, expert opinion letters from governmental entities and agencies. We've also seen 2023 guidance for EB1A, extraordinary ability, and EB1B, where there's new examples of sort of supporting evidence that can weigh more favorably for STEM applicants. However, I think it's important to remember that even though there is this positive guidance for applicants with a STEM background, that doesn't change the standard of adjudication. The standard of adjudication is still difficult. So you need, and restrictive, more so obviously for the EB1A. So you still have to meet that standard. It's just that you've got the opportunity now, I think, to make slightly different, better arguments based upon the evidence that you can bring to the table. However, we are seeing some inconsistent adjudications and RFEs. So really important when you go ahead and file these applications that you really sort of organize, structure, and present the case in the most comprehensive manner possible. So what type of questions, issues, and concerns are you facing as a scientist, as a researcher on a temporary visa? Well, as I sort of mentioned earlier, some of the most common visas that are in play could be the J1, the H1B, or the OPT. So what's the best one to sort of utilize, to hold, to try to obtain? What about a J1? Can I transfer the J1? Well, what about within academia? Do I want to go to industry? Can I do an O1? Should I do an O1? Do I want to stay in an academic position, or do I want to go to industry? What's the balance there? What's how best to navigate? It's not a one-size-fits-all answer. And I suppose ultimately for any foreign national residing in the United States, the long-term question is, well, do I want to be here temporarily, or do I want to be here on a permanent basis? So these are all questions, issues that you got to address. You got to think about moving forward in this visa journey. So what about the international office? So if you're on an F1 and or an OPT or OPT STEM extension, you got to talk to your international office. They are your friend. There is a lot of regulations governing and surrounding the OPT and the STEM extension. I could probably do a whole session on that alone. A couple of things to remember. The post-completion OPT is good for 12 months, and the STEM extension is good for an additional 24 months. Under the STEM extension, you must have a qualifying STEM degree. That was expanded, I think earlier this year, late last year. A couple of notes: the employer must be e-verified, and there has to be a bona fide employer-employee relationship. So the idea of volunteering or self-employment work under the STEM extension, generally not permitted. So as I said, there's a lot of rules, regulations surrounding OPT and the STEM extension. So very important to be aware and have the correct information about what you may be hoping to accomplish. Support that you do not engage in any activities that could be considered to be unauthorized. If you leave academia, so for example, if you finish your PhD, you get your OPT, your post-completion OPT, or you get your STEM extension, and you want to leave academia and utilize that to work in an industry research position, just be careful about the next steps and remember that that can potentially limit your visa options, because the chances are that you're now going to be walking into the H1B cap. There are more limited options for the J1 research scholar in industry. They do exist, but slightly more limited. So again, these are just things to consider and contemplate as you make decisions about your next steps in career, and I suppose professional development and professional positions. Then we have the J1, always being a fairly commonly utilized visa for researchers, certainly in academia. And actually, there's a lot of good about the J1. Generally speaking, you do not have to deal with USCIS, which is not a bad thing. Generally speaking, also easy to administer and is transferable within academic settings. If you're married, your spouse can apply for J2 employment authorization. And there's also some tax treaties that may give you some sort of short-term benefit. However, we also have to be aware and cognizant of 212E. What is 212E? 212E is a 2-year home residence requirement. The J1 is an exchange visitor program. So in certain circumstances, generally speaking, if you got government money, either US or your home government, or you are on your country's skills list, you may be required to return home for a 2-year period before being able to get a H1B, before being able to change status, or before being able to get a green card. So if 212B applies to you, the 2-year home residence requirement, you either need to get a waiver of that or fulfill it. It doesn't go away. You do need a waiver to get either a H1B or a green card. And as I said, you cannot change status if 212B applies. As I said, it is a 2-year home residency requirement. So if you're unable to or don't really want or need to get you don't need to get a waiver, you're just going to go home for 2 years. Home does mean home. It will be to your, generally speaking, your country of citizenship or last permanent residence. If there is a discrepancy on your DS 2019 or your J1 visa stamp, you can potentially look at getting an advisory opinion from the Waiver Review Division, State Department Waiver Review Division, to provide feedback on whether in fact you're subject or not. And that would be on a sort of case-by-case basis. Then we move on to the H1B. Big question on the H1B is whether you are CAP subject or CAP exempt. So basically, academia is exempt from the CAP. So any universities, also nonprofit research organizations are going to be exempt from the CAP. They can file a H1B visa on your behalf at the time. However, industry, and I use that term very broadly, is subject to the CAP. So as it says there, academia is exempt from the CAP and a H1B can be filed on your behalf at any time. That is not the case with industry. There are 85,000 H1Bs available for industry. That's 65,000 regular and 20,000 masters. Generally speaking, you're going to have to enter a lottery. For the last couple of years, the lottery has been heavily oversubscribed. If the employer that wants to hire you, they'll enter a lottery on or around February of March. That will then be undertaken at the end of March, start of April, and then if selected, you can file a H1B for a start date of October 1st. So just like the last few years, the CAP was indeed met for this fiscal year, which just started on October 1st. So a lot of people who were selected for an industry H1B in the spring are now just starting their H1B positions. Unlike the F1 and the J1, the H1B is dual intent, which means that can be maintained up until the day you get your green card. So generally speaking, you don't have to worry too much about employment and travel issues. You can continue to work and travel on your H1B. Within a university setting, know the policy where you are. As I said earlier, titles and positions matter. Some universities, international offices may file H1Bs for certain positions. Other universities or research institutions may not file H1Bs for quite similar positions. That's procedural. That may be their prerogative. So important to have conversations in that regard. Under the previous administration, we definitely saw higher levels of scrutiny and issues in terms of standards of adjudication, certainly with wages and types of positions, certainly in computer programming, network engineering, things like that. Under the current administration, that is certainly less of an issue, but it still crops up from time to time. That could be an interesting dynamic in terms of what happens next week and beyond politically. We also have the O1. So what is the O1? Why are we talking about it? And is it a good option? Well, first of all, it's a much more restrictive standard than the H-1B, the H-1B being a specialty occupation. Generally speaking, most research occupations require a bachelor's degree or above, and it is in a specialized area, so they're going to qualify. The O1's different. You have to show that you're one of the few at the top of your field. And the standard of adjudication is very similar to the EB1A, extraordinary ability, that we're going to talk about in a couple of minutes. You have to show that you have sustained a claim, and it really is a high standard of adjudication, so quite a restrictive standard to meet. You really got to have pretty solid substance and accomplishments behind you. A couple of important things to note about the O1. If you are subject to the 2-year home residence requirement, so for example, if you're here on a J1 visa and you do have that 212E issue, a waiver is not required to obtain an O1 visa. However, what would have to happen is the employer would file the application on your behalf. Once it is approved, you would leave the United States and return in O1 status to commence employment as an O1 non-immigrant. Important to note, under that scenario, the outstanding 212E 2-year residence requirement would still apply. But it certainly is a good short-term option if that's a wrinkle that you have to deal with. Great option for industry if and when there are no H-1Bs available because there is no cap on an O1 and it can be filed at any time. There's no discernible time limit on an O1, so you can also extend it for a pretty lengthy period of time. As I said, it is a restrictive standard, but the 2022 deference to STEM that I referenced earlier has helped. There's no question that this has enabled additional applicants to be approved, certainly with a STEM background, than perhaps would have happened previously. So I think there's that balance with the O1. It is a difficult standard, yes, but the current guidance does certainly facilitate more successful applicants with a STEM background. So as you sort of navigate these different visa options, where is this bringing you from a sort of career and professional development standpoint? Maybe you start feeling constrained with regards to your visa situation or what options might be on the table. And I think if that's the case, it's important to look at your alternatives and to ask yourself some of these questions. So first of all, do you know your employer policies? What is on the table regarding options on different visas with your employer? In an academic sense, or even in an industry setting, is either institutional or company sponsorship a possibility? How do you approach these questions? When's the best time to have these questions? Possibly not on day one of your H-1B. You maybe don't want to be knocking on your manager's door in an industry research capacity or setting saying, hey, do you sponsor for green cards? But I think it's good to have a conversation at an appropriate time. It is important to remember that as highly qualified individuals doing important work, you do have options that many other highly qualified professionals in the United States do not. And that is important. There are pathways and avenues that are available to individuals with a STEM and research background that tends to be more difficult for other professionals to navigate. So for example, are you aware of self-sponsored green cards? And the research can still be undertaken outside of academia. I think USCIS, immigration, now recognize and understand that as long as you frame your application as a researcher, same or similar fields will allow you to facilitate ongoing work, not just in an academic setting, even though that's where you may be at the time of filing. So you do have options moving forward, but it's clear that given the current situation with regards to the visa bulletin, visa availability, and how this all plays together, that you need to strategize and start thinking about multiple steps ahead. Again, I referenced people from India and China earlier, but everybody now has to play the long game. You really need to start thinking 2-3 steps ahead. So what's the difference between employer-sponsored and self-sponsored green card applications? Well, employer-sponsored is what I would term the traditional method of getting a green card. You hear about being sponsored for a green card, and is somewhat easily navigable if your employer commits to the process. But that's not going to be the case for everyone. and it gives slightly less flexibility because you're tied to your employer. The self-sponsored process allows you to drive this bus. Okay, so therefore it gives you additional options and can open doors that an employer-sponsored application, at least in the short to medium term, does not. But it's a restrictive standard. Okay, so I think to be prepared and understand the process is important. What about transitional or non-traditional fields? Are they allowable? Possibly yes, likely yes, but keep in mind that it should be in the same or similar field as that under which you petition. Ultimately, if you can process a self-petitioned application, you're going to have more options regarding ongoing and medium to long-term employment. Employer-sponsored green cards, this is just basically an informational slide because obviously each employer would have their own prerogative in terms of filing. But in an industry-based setting, you would generally be sponsored under PERM. That's what I would term the traditional method of getting a green card. The employer files, or advertises the position rather, to see if there's any qualified US citizens, permanent residents, and you file with the Department of Labour. And if that is certified, then you can file with USCIS. Similar situation for PERM special handling in a university setting, although there is a special process for universities which allows them to recruit the most qualified applicants. So it's a little different. We also have the outstanding researcher, outstanding professor or researcher. That's an EB1. So that tends to be quite attractive, potentially more attractive than the other options because of the EB1 criteria. There's no advertising, almost like a hybrid between an EB1A and an EB2 NIW. There are 6 criteria, and you must meet at least 2, plus having a minimum of 3 years research experience. Important to remember that this is an employer-sponsored application. They must have at least 3 full-time employees, and the position is permanent. That can include tenure track, or at will. So these are all employer-sponsored. So these are not options that you can pursue individually. So what about self-sponsored green cards? This is where, again, is this something that you can consider as an individual? And if this is something that you are considering or contemplating, here's some questions to ask yourself. So first of all, what is it? Well, it's a self-sponsored application. Just as the previous slide discussed employer-sponsored, this is self-sponsored. So you're the one driving the bus. You have control of your own sort of destiny, I suppose. So what are you asking? Well, as I like to tell people, it's actually quite a fancy way of asking quite a simple question. Do I qualify for a green card? Do I qualify for a green card as an alien of extraordinary ability? Do I qualify for a green card as an advanced degree alien performing work in the US national interest? That's really the question that you're asking when you file one of these applications. So logically, the next question that you should ask are, well, am I qualified? And I think it's important to remember that strong professional credentials are required. So the importance of your work in and of itself is not enough. What I like to tell people is, all of the research is important. Not all of the research is significant. So it's important, I think, to have that strong credentials behind you when, in fact, you decide and make a determination to file one of these applications. So what can you do? Well, I think preparing yourself and getting ready, thinking 2 to 3 steps ahead. And as I say there, getting a full and frank sort of evaluation of your credentials is important to understand where you do in fact stand with regards to these types of applications, and B, is it the right time to file? I mean, I appreciate that, getting an approval or moving this process forward for yourself can be a very important step or steps to take, but it's also important to do it at the right time. And as it's not a one-size-fits-all answer, people's research, credentials, attributes, accomplishments are different at different stages in their career. So just keep in mind to pursue this in a manner that's what's best for you. You also have to have the intent to continue working in your field in the United States. However, as I mentioned earlier, you're not tied to a specific employer. So what you're saying is that this is my application, and upon approval, I will continue to work in the same or similar field of employment, research, whatever that may be. One other important thing to note is that you do not actually have to be physically present in the United States to file this application and or obtain your green card. So if, for example, you had to leave the US, if you ran out of temporary visa status, or in fact, you decided to go home for a period of time, maybe that was to fulfill your 2-year home residence requirement, you could actually apply from overseas and return to the US at an appropriate point in the future with your green card. You can actually also file it while you're here and then leave and wait for your green card abroad. So at the end of the day, if you have to leave the United States for a short or medium term period of time, this is still an option that you can pursue and ultimately see your long-term future in the US, even if you need to leave in the short to medium term. So what are the standard of these self-petitioned categories? Well, first we have extraordinary ability. A highly restrictive standard, probably one of the most difficult standards to meet. You have to show that you've got sustained national or international acclaim and that your achievements have been so recognized. If you have a one-time major and internationally recognized prize or reward, if you've got a Nobel Prize sitting on your mantelpiece at home, you're good to go. Generally speaking, most will try to meet it. However, out of the 10 listed criteria, ultimately you have to meet a minimum of 3 out of 10. And then you have to show through a totality of the evidence that you're one of the few at the top of your field. Important to remember a couple of things. Number one, certain criteria are objective versus others being more subjective. That's important. And not all criteria do in fact pertain to the sciences. There they are. So for EB1A, important to remember that we look towards the plain reading of the criteria, the plain language. So for example, some people get excited because they're a member of a professional organization without sort of looking at the full language of the criteria and seeing that it's a membership association which demand outstanding achievements of their members, not a $50 or a $100 payment. Are your prizes or awards for excellent, are they nationally or internationally recognized? These are important to remember. Certain objective categories is judge of the work of others. Generally speaking, if you have peer reviewed for journals, judged grants or something similar, you would be expected to be granted that category. Similarly, once you have authorshipped scholarly articles in professional journals, you should be granted that category. However, other criteria are more subjective. If we look at the original contribution category, that's certainly an important one to look at. It's also important to understand the subjectivity of that. We have to show that you have original scientific contributions of major significance. So certainly your original contributions would be thereof. They could be seen to be significant, but can they be seen to be of major significance? So that little word major can in fact carry a lot of weight in that category. If and when you meet 3 of the categories, you then have to show part 2 and meet part 2 and show that you're recognized as one of the few at the top of your field. Sustained national or international acclaim, what I would term a consistent career of excellence. So it's not an easy standard to meet. And I think that if this is something that you're going to contemplate, go into it with your eyes open, and really important to make sure that you have a pretty overall and substantial overall body of work behind you before you make a decision to file under this visa category. Then we have the EB2, Employment-Based Second Preference National Interest Waiver. So what are we looking at here? So almost certainly a better alternative for postdocs and early to mid-career researchers. However, we're starting to see some more inconsistent and a little bit more restrictive RFEs when we look at the context of how this test governs the national interest waiver, and we'll touch on that a little bit more in the next slide. So what are we looking at? As opposed to the EB1A, which tends to be more categorized, here we're looking at more of a sort of cumulative and broad analysis of your overall body of work. But again, I want to drive this home. The mere act of publication and presentation in and of itself won't be enough. As in the EB1A, this is a self-petitioned application, so you drive the process. We're looking at continuation in your field, and it's not tied to any specific employer. So what is the test? Under the EB1A, we looked at the matter of Kazarian. Here we have Dahanasar. So the first part of the test is, can you show that your work, your proposed endeavor, carries substantial merit and national importance? And there's no question that in this context, the proposed endeavor matters. How you frame it, how you structure it, and how you convey your proposed endeavor to USCIS matters. You then move on to part 2 of the test, which is, can we show that the foreign national is well positioned to advance the proposed endeavor that was outlined in part 1, and ultimately whether it would be beneficial to the United States to waive the requirements of labor certification and the requirements of a job offer, i.e. would the US or does the US want this individual to be here on a permanent basis, regardless of testing the labor market. So all 3 parts of the test must be met, and if so, then you can obtain approval under the EB2 national interest waiver. So what are we looking at in terms of the supporting evidence, how to frame these applications, structure it, what are USCIS? Certainly for researchers, I think it's fair to say that citation continues to carry a high degree of importance, and certainly not a question if you're a researcher applying under EB1A, you're going to want to have a strong citation history. Now, caveat, obviously, citations can differ from discipline to discipline. So, I'm not necessarily going to sit here and put a raw number on it, but I think you're going to want to see a sort of solid citation. Less so in the EB2 NIW, but certainly the idea of recognition and reference from others carries more importance in the EB1A. Look towards not just the articles that you've published, but the potential of cover articles, editorial highlights. Let's look at standards of publication and journal rankings. Keep in mind, the burden is on us. The burden is on you as the petitioner to educate and provide the type of information that will enable the immigration officer to come to a positive determination on your behalf. You have to provide that to them. What about the idea of others having utilized or implemented your findings? How does that drive the narrative forward? Can you document grants and external funding of your work? Strong recommendation letters is important, certainly for the EB1A, potentially less so for the EB2 NIW, but I still would be a believer in obtaining recommendation letters because they do tend to serve to corroborate the evidence in the record. And it just is another door that you can sort of, or another tool, I suppose, at your disposal. You don't want to maybe file an application without letters and then get an RFE asking for it. End of the day, you got to show that you're one of the few at the top of your field if you want to qualify EB1A, and that the proposed endeavor carries substantial merit and national importance, and how well positioned are you for the EB2 NIW. What do I need to bring to the table? Well, everything that you engage in professionally is all the types of evidence that will sort of substantiate and corroborate your case. As I mentioned in the previous slide, grants, funding, publications, peer review, citations, expert opinion letters, recommendation letters. A broad and solid application is probably going to involve these types of evidence. However, if you're in an industry environment, you may be able to bring different types of evidence, potentially reports, more substantial statements from you and your employer about the overall importance of your work from a national interest perspective. So again, approaching this from your own individual background, your own individual situation is important. Networking, professional relationships are also going to carry weight. Again, not every case might need recommendation letters, but I suppose at the end of the day, if you are an earlier career researcher and you've got maybe not crackerjack extensive amount of evidence, then letters from your professional relationship and your professional network can be helpful to your case. what can you do upon approval of the application? Where does this bring you? What about the idea of transitional and potentially non-traditional careers? In a self-sponsored application, as it says there at the bottom of the slide, you are generally required to continue working in the same or allied field of endeavor. And I think, therefore, it's important that that can sort of pivot across professional fields or from industry into academia, as long as you're continuing to engage in the type of work that you were involved in when you applied. So again, slightly case-by-case basis, and for the majority of people who continue working in the same position or an allied position, that's not really a problem. If you are going to pivot away from the type of position that you engaged in at the time of filing, potentially proceed with caution, given that you do need to continue working in the same or allied field of endeavor. So let's say that you've got the qualification, you filed for the green card, immigration have approved the underlying application, sounds good, ready to get our green card, not so fast. So what does retrogression mean? Well, the United States gives out 140,000 green cards every year under employment-based categories. And that sounds like a lot. This is also a country of 350 million, and there's at least 85,000 H-1Bs every year, plus we've got all these H-1Bs in academia. There's other people in J's and F's. So there's a lot of people vying for employment-based green cards. No one country or countries can take more than 7% of the quota, which has led to significant backlogs for India and to a lesser extent China over the past number of years. So where do we stand today? Today, as we move towards the end of October, I have the October visa bulletin. We're going to work off of filing dates. So for EB1, employment-based first preference, all countries are considered to be current. What that means is that if you file for and or are approved for an EB1, A or B, you can essentially move to the next step and adjust status to permanent residence based upon the application that you filed. India has a priority date of April 15th, 2022, and China has a priority date of January 1st, 2023. What that means is for Indian nationals, you would have had to have filed your EB1A on or before, your EB1A would have to have a priority date. We'll get this a point about that in a moment, of April 15th, 2022 or before. For China, it's January 1st, 2023 or before. EB2, employment-based second preference, that would consider both NIW and PERM. All countries are August 1st of 2023, so you had to have filed your EB2 on or before August 1st of 2023 to avail yourself of the ability to adjust status. China is October 1st of 2020, which is about 4 years behind, and India is January 1st of 2013. But the reality is we have no idea how many, the multitude of Indian cases that are in the pipeline, that at the end of the day, that date is possibly not reflective of reality. So how does that play for everyone, and in particular Indian and Chinese nationals? So for all countries, we saw a modest movement forward in the October bulletin. That does not necessarily bode well moving forward from this point, but we got to keep an eye on it. The visa numbers will continue to move forward, possibly on a quarterly basis. We didn't see additional movement in November, so January may be the next time things do in fact move forward. So if you've already filed your EB2 NIW and you're from a country other than India or China, basically keep an eye on the visa bulletin each month to see when they reach your priority date. For China and India, this is important. You can hold your place in line by filing an EB2. That establishes a priority date for any subsequently filed EB employment-based applications. And I think this is especially important for Indian nationals. So I think in many cases, sort of Indian nationals look at that EB2 date and almost say, well, what's the point? Well, one of the points is that by filing an EB2 earlier, you're establishing an earlier priority date, and then you can actually continue to enhance your portfolio for a potential EB1 filing maybe 12 or 24 months down the line. And lo and behold, your priority date would potentially be close to being current at that time. So that's an important strategy. Also, the fact of the matter is that an EB2 approval will A, allow you to extend your H1B beyond the 6-year limit. And also, if you're married and you have an approved I-140 or EB2, even though you may not be able to file for your adjustment, right now we still have the ability to file for an EAD, an employment authorization document for a H4 spouse. So those are all sort of factors that can possibly drive the narrative in terms of filing an EB2, getting that priority date, especially again for India or China. There's going to be a long wait time. And for Indian nationals, then looking towards the next step and ultimately the goal of an EB1. So as you sort of get towards the end game here, be able to look at this in a pragmatic sense. What is in front of us is what is in front of us. And so we have to deal with it. And, there's no question. These are difficult issues and hurdles. Not everyone may work it out. It's hard. It's not easy. But if you prepare yourselves and take steps and learn what is in front of you, taking into account or consideration some of the topics, issues, and factors that we've looked at today, you can take positive steps to help yourself. Now, there's no question that the extensive visa usage is changing the dynamic for everyone. But remember what I said at the start, be ready to be flexible and look at this in a short, medium, and long-term manner. Because at the end of the day, in the United States, science is recognized as being important, and so are international researchers. Science is international. You guys can't come here. I even mentioned earlier, maybe you go home for a little bit, maybe you come back with a green card. But at the end of the day, taking steps, looking at the options here, maybe it takes a little bit of extra time to get the industry or whatever you may want to do, but with the proper guidance and preparation for yourself, filing strong cases at the right time, you can get to where you want and need to be. And that's a positive sort of avenue and pathway of a potential, green card application. And again, professional development, career development options. I'm going to finish with some housekeeping and then we'll have some time for Q&A. So if you need to make a new visa stamp, please be made sure to set up well in advance. There are delays in administrative processing that you may deal with. There is a pilot program for certain internal visa renewals, which has commenced. A couple of, on the other side of the coin, I'm not sort of here, or shouldn't need to sit here and say don't drink and drive, but if you get a DUI or a DWI, you could get your visa revoked and then you would have to end up back at a consulate. You do not need a conviction for that to happen. We are in an era of extreme vetting. Social media, phones, computers, passwords are in play at points of entry. And we'll just finish on the politics of it all. So not only is the election cycle back in full swing, but we've got 1 week to go. So as they say in Encanto, I think it's Encanto, the Disney movie, we don't talk about Bruno, so we're not going to. We are going to see a lot of rumor and conjecture over the coming weeks and months, regardless of what happens, and especially if one candidate wins over the other. But with that in mind, I would suggest to stay informed, but stay grounded. The sky hopefully isn't falling in on high-skilled immigration because STEM is now in play. I know sometimes this can feel frustrating, but that has been a big step forward. The guidance is helping, and so therefore the options are there to pursue. So with that, I will say thank you. Thanks for having me again this year. It's always a pleasure to speak to you guys and assist INet with the sort of yearly session presentation. You have my details. My details are also on with INet. And with that, I'm going to stop sharing and hand it back, and we'll have some Q&A.
That was very informative. Thank you so much, Brendan, again. I'm sure that there are questions, so let's move to Q&A. And I'm gonna get started, and Janice will co-moderate with me. So the first question is, what does e-verified mean? You mentioned that when you were talking about the
Yeah,
OPT stuff.
yeah, just quickly. E-Verify is a government sort of program or protocol that allows employers to basically have their information within in a system that they can then be e-verified as an employer. Most universities and things like that would be e-verified.
Can you hear me? Okay.
Yep.
So another participant said, thank you for all the helpful information. And the first question is, normally, how long would it take to get the J1 waiver? And then the second question is there a certain period of time that a person with J1 visa is not suggested to do international travel during green card application?
Well, and the difficult questions to answer, because different, I don't know how many countries are in the world. We're up at what is it, 180 or 184, something. I don't know how many countries are in the UN. So those are 180 plus different potential governments that you're dealing with in terms of what is the timeline to deal with these different governments and how they facilitate a waiver. Um, so hard to say. J1 waiver, no objections, are inconsistent in terms of the timelines, and even from similar countries. I've had them go through in a couple of months, and I've had others take 10, 12 months. Um, it's important, I think, to give yourself enough time and try to start with enough time to be able to get it through. Excuse me. Travel on a J1, all I will say is this, is that if you hold either a J1 or an F1, as I mentioned in the talk, and if you are pursuing a green card application, I think any time that there would be international travel in play is to proceed with caution and get professional advice with regards to your situation. And I don't really want to go further than that because I would be reticent, for someone to sort of take reliance on something I might say and go travel. You got to make sure and talk to someone about your own individual situation.
Great. So the next question is, how does one transfer from an academic postdoc trainee J1 visa to an academic non-faculty staff position H1B visa? I'm currently acquiring the J1 waiver.
Well, I mean, if the question, and if I'm hearing you correctly, the question is, look, if the person is staying in academia, then a university can simply, once the waiver comes through, simply file the H1B on their behalf. If that's not the case, and they're looking at an potential industry-based application, then they're going to have to enter the lottery.
Another participant is saying, so when is a good time to apply for whether before my J1 expire, and can it be done anytime? Does it take around since 6 months or longer? Or I just want to get the weather done and be ready for H1B transition before my J1 expires.
Yeah, I mean, like as I said to a previous question, I think looking at timelines for J1 waiver applications is a little difficult because we have to sort of look at it on a case by case and indeed maybe country by country basis. Um, you know, you also have to contemplate or consider how much time you were issued on your DS 2019. So generally speaking, you're eligible for up to 5 years. Some institutions issue them on a yearly sort of rolling basis. So at the end of the day, I suppose you want to give yourself enough time to be able to get the waiver with enough J1 time. So unfortunately, I think you would have to look at it from your own personal situation, consider what you have on your DS 2019 and pursue it at whenever the time is right for you. Again, pursuing a waiver and then the potential for travel outside the United States after filing the waiver is also something to contemplate.
Um, so another participant is asking, can I extend my OPT if I submit the green card application in the first year of my OPT?
Well, I'm not going to get, as I think, as I said at the outset, I'm not really going to get into specific questions over, that would be on a legal standpoint. Again, I would urge anyone with a specific question in relation to a legal aspect or of their situation, they should really obtain specific advice.
Another participant is asking, so what happens if I get a job with an international organization like the UN or the WHO outside my home country while serving the 2-year ban? Will I still require the whether to pursue immigration visas in the US?
Well, international organizations can, depending upon the position, can conceivably issue what's called a G4 visa. So the World Bank, UN, things like that. A G4 visa is often issued by them. So if the person was outside the United States, for example, serving out the 2-year period, they would still be eligible to obtain a G4 visa. So let's say, for example, they had left the US for 12 months and an international organization came knocking at their door and said, well, we want to give you a position and we have a position for you in Washington, D.C. at the World Bank or in New York at the UN, and we're ready to give you a G4 visa. Would the person be eligible for that? Yes, they would. And so let's say they got the G4 and they came to the United States. If they had only, for example, served out 12 months of the residence requirement, they would still be subject to 212E. So they would not yet be eligible to get a green card. They would not yet be eligible to get a H-1B visa. So they would be able to come back on the G4, but that 2-year residence requirement could potentially still be hanging over their head.
Okay, the next question is, for how long would you need to stay in the field of your endeavor? I would think before applying for a green card.
Well, I cannot really provide, answers that people may say, oh yeah, and then they end up in a conversation or with an immigration officer and say, yeah, there was this guy in a webinar told me I only needed to spend 5 months or 7 months or whatever that is. So again, when you're talking about the idea of how long to stay in your field of endeavor, working in the same or allied field, I think that should be looked at again, case by case basis, and it would not be something I would want to sort of specifically reference in this context.
And so another question is, I wonder if a student with F1 visa, but subject to the 2-year home residency from previous visa status, is eligible for R1 visa to work with a religious institution. The job is not exactly in the field area, but had some transferable skills.
Well, again, I can't speak to specific positions or specific questions. I'll refer back again. If you're subject to the 2-year home residence requirement, you are not eligible to change status. You are not eligible to obtain a H-1B or L visa stamp. You're not eligible for a green card. There are other visa options that you may be eligible for. However, if you have not obtained a waiver or fulfilled the 2-year requirement, that would still apply to you regardless of whether you got that other visa.
The next question is, what do you mean by filing an EB2 to establish a priority date? What do you need to do to file an EB2? Is it the same for EB1?
Well, an EB2 is just employment-based second preference, and that would be filing an EB2, a national interest waiver application, for example. An extraordinary ability is EB1. So employment-based green cards are designated via different categories. So you have employment-based first preference, which includes EB1A, extraordinary ability, EB1B, outstanding researcher, or EB1C, multinational executive or manager. Then we drop down to EB2, employment-based second preference. PERM could be a PERM application or a self-petitioned NIW. So generally what I'm referring to is that if you're from India or China, for example, and you want to establish a priority date, you would either have an employer sponsor you for an employment-based second preference application under PERM, or you can self-petition under the national interest waiver.
Another participant is asking, usually how many citations are considered good for EB1A applications for Indian nationals?
Yeah, I mean, and that depends, right? I mean, I think that's why I mentioned, different disciplines are different. And so, we can look at raw numbers. But really, I tend to prefer to look at each person's, if someone, is sending me a CV, for example, we look at the potential strengths of their overall application. Now, could the citations be deemed a weakness? But also, you have to remember that different fields of study lend themselves to different strengths. And for example, someone, I live in DC, but like Goddard, which is a NASA, there's a lot of aerospace engineers out at NASA and Goddard, and they may be extraordinary in their field, but they may not be heavily cited because that field of study does not necessarily lend itself to significant citations. And I think that's why you got to remember and think about context. And so I don't think it's as easy as being like, well, I've got 301 citations, so I'm extraordinary. Oh, I've only got 298. I'm not. I don't think it's that easy.
The next participant says, thank you very much. I have a couple of questions. One, do we have to go outside of the country to renew our J1 visa stamp, or can we do it at an immigration office? Two, how long does it normally take for an Iranian to get an I-140 for H-1B? And three, is there another way for the H-4 holder to get an EAD? Can they start a PhD, for instance? So the first question, just to remind you,
first question, you got to go outside. Got to go outside for the J1. The pilot program is for H-1Bs under certain limited circumstances. I don't understand the second question because it's talking about an I-140, which is an immigrant petition, and a H-1B, which is a non-immigrant petition. What I will say is, if you're talking about how long the I-140 takes to be adjudicated, that should not be based on country of nationality. That is supposed to be based on immigration's processing times. EB2 national interest waivers, right now, I'm seeing them be adjudicated in the 6 to 9 to 10 month range. Can someone on a H4 get an EAD without the principal getting an I-140 approved? No, that would be the way that they would get it. Otherwise, they would have to go and pursue their own visa status themselves.
Another participant is asking, is citizenship during filing for visas determined by place of birth or which country your passport is from? For example, what if I was born in India, but I hold a citizenship in another country? Do the restrictions you mentioned about India apply to me?
Yes, it's country of birth. So, and that can work both ways, right? I mean, you could be, let's say you were born in India and then your parents moved to London in England when you were like 18 months old, and you're like, well, I'm British, really, not for US immigration. You were born in India. Now, the reverse can be true. Let's say your parents were living in London and you were born there, but you grew up in India and you're ostensibly Indian. But if you were born in London, you would count against the UK numbers. So it's country of birth. One other just point I'd like to make on that is that there is something called cross-chargeability, whereby if your spouse is from another country, so let's say for you, for example, you are from India, but you're married to someone who was born in the United Kingdom, then you can use what's called cross-chargeability, that both applicants would be able to count against the spouse's numbers. So all other countries. So
the next question is, if both me and my spouse apply for a GC, say in EB1, and one of us gets processed before other, can the other get added onto the other's application, or will we have to stick to our individual applications?
Well, basically, getting a green card as the derivative. So basically, the United States gives derivative status for any spouse and children under the age of 21. So let's say, for example, there's two scientists married together. They both decide to file their own applications. They would both be listed on the I-140, but it only needs one of them to get approved. And then you can follow to join and get your green card based upon the principal applicant's approval. So actually, it's not, a lot of the times, because it's not an uncommon situation whereby, a husband and wife or two partners come to our office and say, well, look, me and my spouse are both scientists, should we both file? And I'm sort of like, well, why don't we look at who's got the stronger application and just file one case? Because if you're going to a lawyer, they're going to charge you twice to do two separate cases, where we say, well, look, let's just figure out which spouse has the stronger case and just pursue that, because both spouses get a green card at the end of the day.
And another participant is asking, is there a specific time limit for holding a J1 visa, particularly for individuals who have been on J1 visa for approximately 7 years while completing a master's and PhD program? Would they still be eligible to undertake an additional 16 months of academic training, or would this
that's a legal question that I wouldn't have. I mean, I could look it up, but I mean, I'm not going to have that off the tip of my tongue. Generally speaking, the J1 Research Scholar Visa, for example, which most research universities use, again, J1 Research Scholar Visa is good for up to 5 years. There are some limited exceptions for 6th and 7th year. There's other regulations and specifics that pertain to academic training and so forth.
The next question is there any advice for adjustment of status for DACA holding PhD student?
I'm sorry, any what?
DACA, DACA.
Yeah, DACA, yeah. But what was the first part of the question?
Is there any advice for adjustment of status?
It's complicated. And so therefore DACA is, I don't want to get into, I can't get into specific advice in this forum. I would urge that person to get specific professional advice or opinion.
And another participant said, hi, my J1 visa ends in 2 days, and I just got my I-129 petition approved, but I'm waiting for the I-797 form to go back to my home country to get my passport stamp for a H-1B visa. Can I still apply for the green card lottery this year? And the home country is France.
That should not be a problem in applying for the green card lottery.
Okay, so the next one is, how long does it take to get H4 EAD for Indian spouses after I-140 approval under EB2 NIW?
Generally speaking, if the H4 EAD application is filed concurrently with the principal applicant's H1B application, all in the same packet, then immigration would adjudicate all cases together, i.e. they would adjudicate the H1B, H4, and H4 EAD. If it's separate, it's taken quite a long time, a number of months. I don't have the exact time frame in front.
And then another participant says, what happens in case you win the DV lottery while on a J1 visa with a 2-year rule requirement, or if you're on a H1B visa?
If you're on a J1 visa with a 2-year home residence requirement, you cannot change status and you cannot get a green card. If you're on a H1B and you win the lottery, your lottery number must become current. They actually select more people for the lottery than there is numbers available. So your number would have to actually meet, the level to be able to apply, and then you'd have to get it approved within the fiscal year that your number pertains to.
How long before the visa expires can we go out of the country and come back if we have this 2019 extended but not the stamp for the new visa?
All I can say is, in order to re-enter the United States, you need a valid visa. So you need a valid visa to come back.
And there's another question that comes. So if I got an H-1B through lottery, can I change H-1B to my second nationality? For instance, my H-1B is from my country of birth, Venezuela. Can I change it to my citizenship of Portugal during the first years or during the renewal period of my H-1B?
I can't really answer that question. I don't know how relevant it is in terms of H-1B now being country of birth. I mean, if you're talking about an amended H-1, that person should talk to whoever filed the H-1B, actually. I can't really answer that.
There is a follow-up question. The question was, how long before the visa expires can we go out of the country and come back if we have this 2019 extended but not the stamp?
Sorry, go ahead.
This was answered already. The follow-up is there a limit for the valid visa, minimum limit?
If you have a valid visa in your passport, you can be admitted back into the United States. If the visa is not valid, you need to get a new one. I mean, more than that, I can't really tell you.
So can you apply for EB2 visa while on a J1 visa with a 2-year rule requirement?
If you're talking about,
Sorry, go ahead.
No, go.
So what if the J1 visa expires before the EB2 gets approved?
So what you have to remember is, if you're talking about an EB2 NIW, that's got nothing to do with your status in the United States. That's simply, as I said in the session, a fancy way of asking quite a simple question: do I qualify for a green card? When you are pursuing a green card, regardless of filing EB2 NIW, EB1A, whatever that is, you're asking immigration that question: do I qualify for a green card? That does not do anything to your status in the United States. So if you're holding a J1 or an F1 or whatever, you need to be maintaining a valid non-immigrant status in the United States in order to remain here.
Is it risky to go outside of the USA while on STEM OPT, not having a visa stamp? My F1 visa stamp expired 4 years ago.
I'm not answering. I mean, that's a case-by-case basis. That person should seek personal advice.
So how much money should I prepare for applying for the J1 visa and transfer to an H1B visa?
How much money? I mean, the Department of State charges you $120 to file it. I mean, if you're going to seek legal assistance, then yeah, there's going to be attorney's fees and professional fees in regards to assisting you with that process. But I don't feel that this is the forum. I'm not going to start getting into what our fees are and things like that. If anyone wants to contact us, obviously I'll provide that. But this is not a forum for me to talk about fees.
Okay. Any other?
Okay. Yeah, go ahead.
No, I was just about to ask you if there were any other questions because there's no more in the Q&A section. That's all.
I don't see any other questions. We have a couple of minutes. If anyone wants to ask any other question, please fill it in the Q&A. Otherwise, I guess it's a good moment to say that it's always best, as Brendan said, to consult in an individual cases and reach out to get a consultation on one-on-one basis. So I'm going to wait just a couple of minutes to see if we have any other questions coming in. Okay. Brendan, thank you so much for once more. This was extremely informative. It's a very hot topic. Oh, never mind. We have another question. Can we contact you for the NIW process?
Yeah, I mean, we process a lot of NIWs and EB1s for scientists and researchers. So we would welcome anyone if they wanted to reach out to us with their CV or their resume for a consultation or to get an evaluation of their credentials. Absolutely.
Perfect. Thank you so much. And this is really useful for all of us international PhDs and postdocs that we are seeking immigration advice. So please reach out for individual case evaluations. Brendan, thank you so much again. Really, that was great. That was super informative. And thank you so much for your time and for bringing today the expertise to INet's event. And yeah, there is a 10% discount from Frank and Delaney for INet members. So please take advantage and reach out to Brendan with all your questions. Thank you so much.
All right. Thanks again for having me.
Thank you. Have a great night, everyone. And thank you, Janice, for co-moderating.
Sure, anytime. Thank you.
All right.
Yeah,
Thanks
we
again.
can share. So Brendan's information, we can share these also in INet's website. So thank you, everyone. Thank you, Brendan. Good night.
All right. Have a great evening. Take care. Thanks. Bye.
Bye-bye.
Bye.